the issue was whether or not, or the extent to which saliva, go back one step, the extent to which THC enters saliva either through your blood, just the circulation of ordinary way the bodies work, comes into saliva 3 or 4 or 5 days after you've smoked, or is it just a residue after having some saliva, smoke in your mouth, and is it still there? The Dr. Pearl, the primary, well, she was not anymore, but she was the primary expert for the police in these kind of cases, said no, it's just residue, And the magistrate was David Halpin, who's here at MardiGrass, ex-magistrate now, but he asked her, well, does that mean if someone took it by capsule, it would just bypass their mouth altogether in terms of the capsule not breaking in your mouth, so there'd be no... she said, yes, that's right. So she's not a particularly reliable scientist in my view. I would say that with some respect. I don't agree with her about some of the scientific stuff she pushed to the court, so she might be right about that, she might be wrong about that, but there's a bit of controversy about whether THC does in fact enter your mouth, saliva, through ordinary, what I might call, not being a scientist, ordinary bodily processes, that is, through blood, etc., it just comes back into your mouth through saliva in that way. So, yeah. Of course, we were certainly arguing that point. That was our case was that that's a possibility. Criminal law, you deal in what is provable beyond reasonable doubt, and it's up to the other side to do all that. The defence just have to say, well, there's a doubt. Look, I might just do a short presentation. This is going to be largely question and answer. I do hope more people come in, but if there's only the 4 or 5 of us, well, we're 4 or 5 of us, so we can talk. The larger the crowd gets, the harder it is to hear in this room, so I think we've got a roving mic, so it's probably good for questions and answers. And also recording, of course, so some people with loud voices can make themselves heard, but generally it's better if you just grab a microphone if you want to ask a question. I'm going to talk for maybe 5 minutes, that's probably 10 really, about just a general overview about how the law works. Some people know about that, some people know a little bit, some people know nothing, so starting on the basis that some good general knowledge is a good place to start for the conversation. Drug laws are part of the criminal law. That is, as I just said, I think a second ago, it's a criminal offence to, all drug offences are criminal offences. That is, unless you plead guilty to the offence, the police have to prove things beyond reasonable doubt. The offence depends on the type of drug involved, so there's a whole lot of prohibited drugs, as they're called, cannabis being one of them, but there's a schedule to the legislation that runs for page after page after page, all the kind of usual suspects, I suppose, but including various analogues and variations of the of party drugs and the chemical drugs. So that's a long list. Cannabis is listed, cannabis leaf is listed separately to cannabis oil is listed separately to cannabis plant. So there are kind of differences, and there can be some significance about that. The offending depends on what you're doing with it. It's the, although some of us like to talk about the plant being made illegal, it's not strictly speaking the plant that's illegal, it's conduct with the plant that's illegal. So the possession of cannabis, the consumption of cannabis, supply, cultivation, it's the activity that is criminalised. How serious the offence is depends on the category of, there are 5 different categories of quantity, small quantity up to large commercial quantity. At the bottom end, penalties tend to be reasonably not too serious. First offenders generally get not too bad a go. It's not the most pleasant experience to go to court, but you don't go to jail for the first offence of a possession, for example. But if you're looking at commercial or large commercial quantities of cultivation, then certainly almost always you'll be looking at jail time for that kind of offending, whether it's your first offence or not. Bit of common sense, the bigger the quantity involved, the more trouble you're in. The more trouble you've been in before, the more trouble you're in this time round. So if it's your first offence, you're not it's the best position to be in court is as a first offender, although you won't know the system, you'll be a bit baffled. The more record you've got, the harder it is to get a lenient penalty, and it all sort of catches up with you sometimes. The offence of possession involves proof beyond reasonable doubt that you have some kind of physical control over the substance, the weed, and that you know that it's there. So if it's in your pocket, okay. If it's in a locker that you've got the key to, in a car that you've got the key to, in the boot of a car, it's your car, you've got the key to the car, etc. That sense of control is probably established. But do you know it's there? Maybe you don't. Maybe you don't know that there's something in the glove box of your car. So the reason that, generally speaking, lawyers give advice to not speak to the police and not make any admissions and not tell the police anything if you're in that situation of being asked questions is that sometimes, although things might be in some ways obvious, there may not be enough legal evidence beyond reasonable doubt to prove the elements of possession, that is the element of knowledge in particular. So unless you're very confident about what you're talking about, generally speaking, best not to say anything to the police and let them go about their business and obviously be polite and respectful, and hopefully they'll be polite and respectful back. But basically, admitting that something is yours doesn't always help. Making no admissions with the police might mean that there's an argument you might want to have in court about it all. You might say nothing to the police, you might come to court, might get some legal advice, you might say, well, I just got this over and done with. Then you might want to tell the magistrate, yes, it's mine, and plead guilty. You get as much benefit from doing that as you do from making any admission to the police in terms of leniency. The law is about discounts, which is funny language, I suppose. Discounting penalty is based on what you do in court from the beginning of the court process, not what you say to the police, okay? So you don't get it, despite what the police will tell you, you don't get any advantage by making admissions to the police.
Steve,
Yes.
I've always wondered about the don't say anything to police, as in, is it best just to remain mute? As in, do you say absolutely nothing? Like, how does it roll?
You can. You can be just mute. That's very awkward. I mean, the whole trouble about talking with the police is socially we are all friendly people, aren't we? I mean, generally, we all say hello to people. Someone says hello, we say hello back. Someone talks to us, we talk back. It's how we normally operate in society when we're people we don't know, obviously friends and family and so on, but when someone you don't know talks to you, you generally will say something back to them. It's hard to sit quietly or stand quietly saying absolutely nothing. So the best strategy probably, if you think you might be in a position where the police want to ask you some questions about what you're doing, what you're up to, is to have something kind of a bit rehearsed in your head, so you know what you're going to say, kind of what you're going to say. It's a very stressful conversation to have with police, whether you've done anything wrong or not. Most people find it very, very stressful to talk to cops. If you have some kind of rehearsed thing like, I don't have to say anything, so I'm not going to make any comment. And they ask you the next question, I don't have to say anything, so I'm not going to make any comment. And just have some kind of form of words in your head that is clear, polite, but firm, then you're best likely, or most likely, to be able to cut the conversation short. The police are told to ask questions and find out what they can about people or from people, but they're also told if it's clear that the person is not going to answer questions and not going to make a statement, to not press that. So they can ask you 2 or 3 times, but then they'll just give up. They won't keep pestering you for half an hour and shine bright lights in your eyes or anything like that. They'll just accept you're not going to make a statement, and that's as far as it goes. Okay? Look, because we started fairly informally, I should have welcomed everybody to MardiGrass Day 2. Didn't do it at the proper beginning, and I should also really acknowledge that we're on Bundjalung land. That's important that we recognise that on every possible occasion. So although we started out in conversation, it's not too late to recognise that always was and always will be blackfellow land we're on. They've looked after the place so well, I hope we could look after it half as well as the Bundjalung mob have for tens of thousands of years. The offensive supply involves sometimes having more than, in the case of cannabis, 300 grams of cannabis or more. That's what's called a deemed supply charge. So if the police can prove possession of 300 grams or more of weed, then in your possession, then it's up to you to prove it was not for supply. 300 to 350 grams, sometimes a court will have no real trouble accepting that was for your own use and it wasn't for supply to other people. Clearly, the larger the quantity gets, the harder it is to say I was going to smoke all of that. Yeah, 15 kilos, how long going to take, really? There are limits. Not for supply, though, can mean disposal, as in I was going to smoke some of it, use some of it, and I was going to throw the rest away. Half of that was rubbish, half of that was leaf. Not interested in smoking leaf, I was just going to throw half of it away. So it's not, you don't have to say, oh, I would have used all that myself. It just have to be, and again, probably not with the police, more in court, you do have an argument that it wasn't necessarily for supply if a lot of it was going to be disposed of. Smoke some, toss out the rest in the compost. Similarly, though, the other side of that is sharing is also supply. So saying to the police, no, I wasn't going to sell it, I was going to give it to my mates, I wasn't going to sell it, I'm not going to sell it. You're not doing yourself any favour by sort of blurting that out, because that's still admission to an act of supply or an intention to supply. Cultivation is the act of growing a plant, planting the seed, watering it, fertilising it. Harvesting is part of the definition of cultivation. There's also a charge of possession of plants, so even if the police can't prove that you did anything to cultivate a plant, or 300 plants, whatever it might be, or 20 plants, they may not be able to prove the cultivation because you're sensibly not making any admission about doing anything in terms of planting it or watering it. If they can prove you had possession of it, that's in your backyard and you knew it was there, then you will be charged with possession of the plant. The penalties are the same. It doesn't make any difference whether it's cultivation or possession of growing plants. Only other thing I want to say in terms of the general road before we go over to questions is the driving stuff. It's an offence in New South Wales and all other states to drive with the presence of THC in saliva. So if you're, as probably most people would know, and probably all of us were stopped on the way into Nimbin this morning by the roadblocks around town, the police have the legal right to stop a driver and to require the driver to provide a saliva sample. Same as the laws around drink driving. They're allowed to stop you and have a breath sample, take a breath sample. It's random in the sense that they don't have to have any reason for it. It's not random in the sense they have to close their eyes and pick numbers, pick every third car. They can make, random doesn't mean they have to be random in that sense of the word, but they don't need any particular reason to stop you. They can stop you just because they want to. The procedure with drug testing is they do a swab. If that swab is positive, you're under arrest, briefly anyway, taken to a bus if there is one, or a police station, where they do take a sample, do a second part of the test. That sample is put into a little machine, or sample plugged into a machine called a Dragar machine. That gives a reading either positive or negative to THC or the other drugs that are covered, methamphetamine, ecstasy, and amphetamine. If it's negative, away you go. Just you're free to go. If it's positive, you're told not to drive for 24 hours. Either way, that same sample that they take is then sent down to a lab in Sydney. It's analysed by a proper scientist, and if it comes back positive to THC, you get a penalty. 97% of the ones that go down to Sydney to the lab come back as positive. So almost certainly, if it gets to that stage, you're going to get a letter in the mail. They changed it a couple of years ago. If it's a first offence now, you get a fine through the mail. You get a $395, I think it is, fine to pay on the spot, and you get an automatic 3-month disqualification of your suspension of your licence. If it's not your first offence, you've got a driving record, etc., you've got to go to court on the and the magistrate deals with it in the way it always had to be done on first offence. So if you get the ticket, well, if you go to court, you go to court. If you get the ticket, then you can choose to go to court. You can, two things, you can either do what's called a court election, fill in a couple of forms and so on. The court will then write to you, come to court on this particular day. You keep your licence until that happens, so all just sort of stays in place. The magistrate does have a discretion to not impose a conviction, in which case you don't lose your licence. The way the law is structured, if you are convicted of this offence and other driving offences, then there's an automatic loss of licence for a period of time, 3 months, 6 months, depending on the offence and the record. But if there's no conviction, then that does not apply, and you get to keep your licence. So that's clearly what is put to magistrates very, very commonly, kind of all day, every day, really, in some ways. That's the argument put to magistrates a lot of the time. You don't really get a chance to say you're not guilty. Bit of a long story about that one, we can come back to that. But most people don't say they're not guilty to driving with the presence of THC, because all the police have to prove is you're the driver. Here's a sample. The analyst says there's a drug found. They don't get, the report doesn't say how much, it just says present, found THC present. So it's a one-page report. The name of the analyst, the reference number, the kind of serial number of the sample, etc. The date they did it, I think. But there's nothing really that says much more detail. So most people are not in a position to say not guilty. I was the driver, my saliva, okay? So the argument is often around penalty and whether there should be conviction or not. The other procedure you can go through is to pay the fine and then do what's called a licence appeal. That is, pay the fine and go to court on the basis of you should get to keep your licence because of your general good record and fit and proper person to hold a licence kind of argument. So some people these days are doing that, paying the fine, going to court saying, well, except I've done the wrong thing, broken the law, put it that way maybe, paid the fine, but I need my licence for this reason, and this reason. Section 10 is the provision about no penalty. It's a very, very popular provision among people who are facing drug charges. It's the penalty, or the procedure that allows, or part of the legislation that allows the magistrate to not impose conviction. So if you get a Section 10, that's not such a bad result. But you can't get, for driving offences, you can't get more than 1 in 5 years. So you're kind of a bit stuck with that. And in other offending, say for possession charges, most magistrates are very reluctant to give you more than 1 Section 10. You might get one, 20 years ago, then another one today, okay. But you generally don't get a whole string of them. It's a kind of considered a first offender's benefit more than anything else. Not impossible. It's not that the legislation says you can't do it more than once, except in the driving rules, about the 5-year rule. But broadly speaking, for general criminal law, there's no rule that says you can't have more than 1 Section 10, but most magistrates interpret it that way. It's discretionary, up to them. I think that's all I really wanted to say in some ways. There is in the program for MardiGrass a whole page of legal information. Page 18 I happen to notice because I read it. If you want to have a look at the program and read through that, hopefully a fairly clear, plain English guide to most things most people need to know about the drug laws and how they work. Clearly it gets quite complicated, and every particular situation is a bit particular to the individuals involved in their record and their background and their circumstances. So that's what the legal system is meant to do, take account of all of those aspects in terms of the punishment end of things, but before you get to that point, the legal system is meant to look at the evidence properly and deal with evidence rather than morality, I suppose. So whether a magistrate thinks it's a good idea or a bad idea, and there's certainly a mixed bag of opinions that the drug laws are a good idea or a bad idea. The magistrate should be dealing with cases on the basis of what does the law say, what have you done, what can they prove, and if it's a guilty plea, what's your background and what's an appropriate penalty, not necessarily the harshest penalty or the most lenient penalty, but what's the most appropriate penalty for all the circumstances. And that's what lawyers talk about when we go to court. I hope that's all clear enough. Any questions, comments, I think is over to you guys. We've got until, I think, Kath, until 11 today. I think.
5-2.
Yeah, we've got to do a handover. So
Next person. So
we've got lots of time for as many questions as we want, probably.
Yeah, I've got maybe a left field one, but I've always been wondering. I remember in the mid-90s when the internet started getting going, the Queensland government had a bit of a freak out about drug information being freely available. And I believe that they kind of did pass legislation to try to restrict, or they made it an offence to, for example, to disseminate information about, say, growing pot, as an example. So that was an offence to provide the information just as much as it is to cultivate pot. So, and I do recall in the 90s various people getting books confiscated as they were coming into Australia. So yeah, do you have much experience with people being charged with actually having information about cultivation? in New South Wales or elsewhere?
No, to give a straight answer to the question, no experience. Never had a client charged with anything along those lines. There are laws around publishing information that encourages criminal behaviour. So, in a much more serious way, laws around terrorism that encourage people or describe how to make bombs and stuff. That's always been illegal. There's nothing sort of new about that. That kind of stuff has always been, as long as anyone can remember, that's always been against the law. The interpreting whether or not, I'm not sure about the Queensland legislation, Catherine, but I'm not quite sure about that in detail. But some of that legislation about encouraging criminal behaviour can be interpreted. For example, books about how best to grow weed could or could not fall within that category, I think is the best answer to give to the question.
So it's kind of like perhaps a charge that could be added to other charges if required.
Yeah. I mean, there are books. There are shops that sell books. Next door, there's a shop that sells books. The embassy shop has never been raided, as far as I'm aware, about, look, you're selling these books, you're in trouble for selling these books. There's never been a problem that I'm aware of about that. So obviously balancing off that kind of law about it's wrong to grow cannabis, well, is it? But it's illegal to grow cannabis, and we should be encouraging it, against the right to free speech and freedom of information and so on, in that sort of broader democratic society we're expected to live in or supposed to live in, I think does restrain police from interpreting some of those provisions too narrowly, put it that way. But I've had no experience, so I don't think it's a big problem in that way.
That's a relief for everyone with, I guess, psychedelic and cannabis libraries.
I think that might be, if I could see, that might be someone who might be called Cog, who might want to be anonymous, but who might have something to say on this subject.
Yeah, for sure. Yeah, I'm Cog. I wrote the book Marijuana Growers Lot 25 years ago. So my book is totally outside the system. It's never been actually banned, although the police have said right from the start, if anyone buys this book, they'll be jailed. So there's been nothing happened to me over the last 25 years about it, but I have heard 3 cases where people, they've been raided for drugs, my book's been in there, the cops have also taken that book, and they've charged them with another charge, which I think the wording is in possession of producery or something like that.
Okay.
Yes, I do know 3 people have been charged with my book.
Okay.
And also another case, police raided someone, there was guns and cash, and they put a photo up on the internet of evidence. It was guns, drugs, and my book. Yeah, but...
a trifecta.
Yeah, so I've had no problems with the law since then, because I've been to jail before I wrote the book.
Yeah, but for the growing Cog, not for the book.
Yeah, that's right.
Yeah. So, legend, Cog, legend,
Right.
local fella.
Thank
Great
you.
book, by the way.
Thank you for your...
Still available, 25 years on.
That's in the embassy?
Yeah, at the embassy for a very modest price, worth a...
Oh, and also, so if anyone's interested in joining COG's Growers Circle at 11 a.m. down at Indica Arena, you can find more subversive information down there. Yeah. Thanks, COG. That was very good timing.
Yeah, there we go.
Any other authors
It's
of
Nimbin.
drug books here?
Answers to all your questions are in Nimbin. Sorry, anyone want to say anything? Otherwise, we'll go and have a cup of coffee.
Yeah, I was going to
have to.
say, if you do have a question, give me a hoy and we'll
Down the front, I think.
we'll give you the mic. Yep.
Yeah, this isn't really a legal question, but I'm a bus driver. I can't partake in anything, and I'm kind of surfing and yoga and other things that start with S tend to do it for me. So I was just wondering, does secondhand smoke, could that give you a reading if you breathed enough of it? You know, you're just at a party or something.
I think yes. Being a lawyer is a bit of fun, and sometimes telling what we think of as war stories is a very dull thing to listen to. But some of the fun I've had in recent years has been around these laws about driving. There's a defence called honest and reasonable mistake of fact. It's not a new thing, this is an old law. So basically, if you do something that you think you're entitled to do, not because you have a mistake about what the legal position is, but about the factual position. So if you think something is legal and you do it, and you have a reasonable basis for thinking that, then you have a defence to any charge, okay? If I can put it that way. So as a simple example, if your licence has expired and you don't know your licence has expired because you've changed your address, you haven't got the reminder notice and so on, and you think you've got a valid licence but you don't, that's a mistake about whether your licence was current or not current, okay? So you're entitled to plead not guilty to a charge of driving unlicensed. Pretty simple example there. With the drug testing, we ran a series of cases around whether or not someone was entitled to, on that defence, to say they thought they would not have any THC in their system because of all the circumstances. The first case we ran was had a client who said it had been 9 days since he last smoked a joint before he was stopped. The beauty of it really is that once you raise that defence, the police then have to prove beyond reasonable doubt that you did not hold that belief, that is, you're lying, or that you did not have a reasonable basis for that belief. So it's pretty tricky in lots of ways for the police to kind of prove that. So this fellow was quite convincing, came across as quite an honest fella, told some truthful things about his previous experience and how he committed the offence before and so on. Knew all about it, cops had told him this. Anyway, the court accepted that he had a honest and reasonable belief that it had been 9 days between smoking and being tested, and that on that basis he was reasonably entitled to think he would not be positive to cannabis in terms of testing. Then I ran 2 or 3 or 4 other cases on similar arguments but with different fact situations. One of those was about passive smoking, and the fact situation on that one was a woman who'd been living in a caravan park helping her neighbour in another caravan who had late stage cancer, terminal cancer. That fellow had a permission, there's a scheme for people with terminal illnesses who can, this goes back before medicinal cannabis, it's a fairly old kind of thing, only applies to a handful of people. But if you've got a terminal illness, you can get an exemption basically from the police to use as much cannabis as you like. You're just entitled, because the police, as a discretionary thing, will not bust you for using cannabis if you register under this terminal illness provision. So the fella in the caravan next door had that condition and had that permission to smoke cannabis. And my client would go over there every day, help him out, do some of his housework for him, check he was getting some meals and so on and so on. But apparently, on the evidence, he was just chuffing away. He was inside a locked caravan, just chuffing from morning to night, and she was there for half an hour a day, breathing, because she had to breathe, but breathing in his side smoke. She was stopped, tested. She gave evidence that, yeah, I used to be a pot smoker. New Year's Eve, I gave it up. This was about late January or something that she was arrested. Yeah, New Year's Eve, I stopped. I thought, my New Year's resolution, I'll give up weed for this year. But the only weed I've had, or any exposure I've had, has been this fella. And again, the magistrate accepted that was truthful. The police could not prove beyond reasonable doubt that it wasn't. I think before you came in a little while ago, I was talking about Dr. Pearl, who was a regular police scientist they wheeled out for all of these sort of run of 4 or 5 cases that we had at Lismore Local Court. And she gave evidence, no, not possible. But the evidence was, the scientific evidence was a little bit both ways, and the magistrate found that that was a reasonable explanation, and more accurately and more technically, the police had not been able to prove beyond reasonable doubt that it wasn't reasonable for that client to believe that what she believed, that she had obtained it through passive smoking, and it wasn't possible, and the court could not say it was impossible for that to happen. Okay, so it's a funny world, the criminal justice world. You kind of think of it in a slightly peculiar way, I suppose. So I think the short version is, yes, I think there is evidence. Our scientists said, yes, it's possible, can't rule it out. Yes, it is possible. The police scientist says, no, it's not. The court said, yes, it is possible then, so we'll go that way. But the evidence about random testing in terms of how long THC stays in saliva and so on is really young science. There's hardly very much evidence at all about it in terms of scientific studies. When we're running some of these cases I'm talking about now, at that stage, there's been a few more since, but there was a total of 4 studies, kid you not, 4 studies that Dr. Pearl was able to refer to in her material, and our scientists, yeah, that's it, that's all there is. One of those studies involved 10 people. One of them involved people going into a rehab centre and being measured, tested on day 1 and day 5, day 6, etc., and how long, presuming that they had consumed no cannabis in the rehab centre. Presuming, that may not be true, but presuming they didn't smoke anything in the rehab centre. So it was just a handful of cases. There was one with, I think, 8 people, very Cheech and Chong, 8 people in a combi van. Half of them were given weed to smoke, the other half had to sit there in the van. So I always think of Cheech and Chong when I think of that, but anyway, why is that? But that was a passive smoking example about whether the people who had only passively inhaling will also get readings or not. And the science was really unclear. It's just, yeah, maybe. The answer is yes, maybe. And how long? The longest that was detected in those handful of studies was about 24 hours after consumption. But our argument, broadly speaking, was, but that's, we're talking about a total of 65 people, I think, in those 4 studies involved 65 individuals. How can you make broad statements about the general population based on 65, some narrow studies about 65 people? You just can't say anything for sure. There's been a few more studies since. It's getting a little bit more work being done on it, but it's not a high priority. The police have got the law they want, the police have got the technology they want, they're getting lots and lots of people busted, they don't care, they're not looking into it, and there's no one really looking into it from another perspective, really. The Langford Institute in Sydney has done a lot of work, I should hasten to say, around medicinal cannabis in particular, and the impact of driving and so on. So Langford at the City University are doing some good work around that area, but it's a bit narrowly focused on medicinal uses rather than broader uses of cannabis, and the broader picture of how long would it be. We really need 1,000 people or 5,000 people to smoke a joint and then have their saliva tested for a few hours afterwards, so volunteers can form a queue at the front.
Any more questions?
Follow up? That's okay.
He's our plant. Yeah, you're the plant.
Yeah, that second question was... Okay. So, taking a fisherman's friend or apple cider vinegar or some other thing that modifies your saliva, has there been any studies done into those kind of methods?
A lot of anecdote, but no study. Different people say chocolate milk is good, some people say fisherman's friends are good, apple cider vinegar, they're the common things that people tell about. I hear about people who say, oh, hello, fisherman's friend, I got busted anyways, though that's, well, it's so idiosyncratic. My view, it's just so idiosyncratic. Some people, I reckon, test positive after a little bit. Some people test positive after a long bit. You just can't tell, really just can't tell. That's, to me, that adds to the unfairness of the law. I think it's fundamentally unfair because there's no connection between any kind of reading of THC and the impact on driving. There's zero correlation between any particular reading and impairment. That's not to say that some people who are off their face should not be driving. I think that's fair enough. I think most people who are off their face don't drive because they're aware that they can't drive. And there's probably some margins in that. But aside from the fact that it's unfair in absolute terms, it's unfair because some people are going to be past the test and some people aren't. Why is it so? I mean, it's random in one way, but it shouldn't be random in that sense, in my view, that you're just unlucky if your metabolism is the sort of metabolism that holds on to THC for a long time when someone else's doesn't. So we don't really know. The hemp embassy, a long time ago now, when this first came in, it's been on the books for a long time. It only became a real problem for the last 10 years, probably, because they got more buses and did more testing. But when it first came in, Embassy got 50 odd of the samples of the swab devices, because they cost about 50 or 60 bucks each. But anyway, Embassy had a bit of money, so they bought a box and spent the afternoon with some very informal hippie science, and the people who had tried various, chocolate milk, apple cider vinegar, that kind of thing, smoking joints, some were positive, some were negative. There was one particular woman who had, she'd eaten 3 cookies or something. She was off a tree and she was just dancing around. I'm happy, but I'm not going to drive. This is really good stuff, but I'm not going to drive. And she was negative. I mean, she was clearly unable to drive. She knew that. Clearly incapable of driving. Would have been a hazard to anybody on the road. Had enough common sense not to even think about it. But she proved negative. Other people were, positive. People who'd had, long-term smokers were positive because they smoked every day for as many years as they can remember, which may not be that many years, but as long as they can remember. A lot of people were positive. Some were negative, but it just seemed, how do you know? Just all over the shop. So I think although that was a bit of hippie science, I think rings true to me from my experience that people, you talk to people here at MardiGrass who say, oh gee, I was lucky I had to smoke this morning but got through the test, they stopped me, but I got, you hear all sorts of stories from people who don't get busted. But as a lawyer, I tend to talk to people who are busted. So it's only guilty people, only people charged with offences, I won't say they're guilty, only people charged with offences who come to me after the event. So other than that, it's very, very anecdotal. You don't hear about all the times when people are not, found in possession. In the same way that in terms of police searches, a lot of police searches are wrong, but nothing is found, and so no one really complains about it except maybe to their mates. So lawyers don't hear and the courts don't hear about unlawful police searches where nothing is found. Most people tend to let it go rather than make a complaint about it. Of course, once there is drug testing, there's all sorts of companies that jump in to make lots of money. So the embassy was contacted by one of those companies just before MardiGrass. So we actually did shell out some money for saliva testing devices. So if anyone feels like doing that this weekend, the embassy's got some saliva testing devices. And I think we're just selling them for cost price. Maybe they cost $30 each. Anyway, yeah, I haven't heard of anyone trying them out this weekend. But it's true, there's every year at MardiGrass, there's certain full-on smokers we know that never get positive, and then, some poor person that's hardly smokes, suddenly they're testing positive. So it's all over the shop. Following on from that, is there anyone that actually has challenged, that the tests themselves are not reliable? That, for example, that there's false positives and so on. So has that been an argument or that has been used in any case? The difficulty is the testing. What the police do is obtain a saliva sample. After that, the sample, what they do with the sample in the lab in Lidcombe in Sydney is just ordinary science. They put it through a spectrograph machine. It's just ordinary chemistry, basic.
And that's the one with
chemistry
the
101.
97% positive.
Yeah, that's right. So it's not so much that I don't think there's an argument that there's anything fundamentally wrong about the science involved in spectrograph analysis. It's more about what does it actually mean. If there's a reading, a very, very low reading of THC, does that mean anything? So the cutoff in terms of reporting is 10 nanograms per 100 mil. So that's a tiny, tiny, tiny amount of THC. There is no correlation between readings of 500, 1,000 nanograms of THC, for example, in the 100 mil, or 15 nanogram in the 100 mil. There's no correlation that says the 1,000 gram driver must be incapable of driving, the 15 nanogram person must be capable. It could be the opposite. The 15 nanogram person might have never had cannabis before in their life. They might have smoked 10 minutes ago. They are probably, as a first-time smoker, would not be a wise decision for that person to drive a motor car. Someone who's got 1,000 grams might have had a smoke this morning and yesterday, the day before, the day before, be perfectly fine to drive. So it just is irrational in that sense that the reading doesn't mean anything, but challenging the reading itself doesn't make a lot of sense. Where we, a bit of a case that went to a bit of a dead end, at one stage I had an argument that didn't get very far, that it was that the cut-off was wrong. And I think in different circumstances we might run that up another time. That is that it's wrong for the testing to have such a low cut-off in terms of what they report. Collect the samples, send them to the lab, but have a cut-off at maybe 500 nanogram per 100 mil, because you're more likely to get a correlation at that high level between capacity to drive and reading than at the low level. And then make some sort of argument that the police are invalidly exercising their power. It sort of makes some sense in one way, but it's an argument that's half-formed, I think, as a legal argument at this point. Yes?
Sorry? Is it you? Yep, wait for you.
Yep. Just maybe a slightly left field question. So if...
We do left field.
If, so I imagine I'm driving along, I see a random drug testing thing a couple of 100 metres up the road. That causes me to have a panic attack. I instantly pull over due to my mental state of having my panic attack, and I then consume some of my duly prescribed cannabis medicine to deal with my current panic state. Obviously, I would consider that they're not able to get me for driving under the influence if I've removed the keys, turned the car off and all of that, if they come up to me. What do you think of that as a possibility? Is there any other charges of, stopping too early before a drug test? Yeah, just wondering about that as a potential real-world defence against losing a licence.
It's an offence to not cooperate with the testing. Okay, so if the police stop you and you say, "No, I'm not going to give you, you're not going to give you the sample." Okay, same as with the drink driving offences. If you refuse to provide a breath sample, that's an offence of itself. Okay, if you drive past, drive past the roadblock and try to just make an escape, that's an offence of as well of a separate sort. In your particular, go back to your particular scenario though, whether or not, if you use cannabis for medicinal purposes or for any other purposes, does not matter. The offence is to drive with the presence of THC. Driving is defined to be occupying the driver's seat. So once you're sitting in the driver's seat, I think with the engine turned on, sitting in the driver's seat with the engine turned on, you're a driver. Okay. So if you pull over, and you want to, avoid being tested by some officious highway patrol driving past, hop out of the driver's seat. Anyway, so there's a bill before New South Wales Parliament, and I think in the Victorian Parliament as well, about making an exception for medicinal users who have prescriptions, at least, legal prescriptions, to be exempt from the law. In other words, to be allowed to drive even though you're going to have some THC in your system as an exemption. That in New South Wales has been sent off to a committee. Kate Fairman, who's the Greens Member of Parliament, who's promoting that law and through the New South Wales Parliament, is here at MardiGrass. She was saying yesterday there's expecting some debate on that even as soon as this week. On Wednesday, I think, is going to be debated. So there might be some news reports about that the next few days. It's going through a process in Parliament. Kate's view is that it won't be passed this week, but it might be sent off to another stage of committee decision making, and they might come back with a recommendation to do something maybe next year. So she's a bit optimistic that it might happen, but at this stage it makes no difference. Where it does make a difference is when you go to court to say to the magistrate, I should keep my licence because you can say that you're a medicinal user. If you've got a script, you've got a script. It is taken into account in terms of whether or not you get the Section 10 or get to keep your licence. It's a part of the argument about the penalty, but it doesn't provide a defence itself, as in you are still guilty of the offence of driving with THC present in your saliva. And then you hope for the best in terms of penalty, keeping your licence in particular. Up the back.
Thank you. I've got a question. There are ways of invalidating saliva tests. So there's a whole range of things you can do to make it less likely that you would test positive. If you're is it illegal to communicate that to people who are prescribed medicinal cannabis? So, because is there a law which you're interfering with the police's process of busting people, that if you were to say to consumers, so for example, look, if you wash your mouth with Listerine alcohol-based mouthwash, that will probably stuff up the saliva test. Is it legal to communicate that? And in the context of, look, you shouldn't be driving, buddy, if you're on the medicinal cannabis, but in the event that there's an emergency, you know, the house is burning down and you've got to jump in the car, just in case that ever happened, I'm giving you this information, but of course, buddy, you shouldn't be driving.
No legal problem, as it is not an offence to share that information. It is not an offence to say to people, a good rinse of Listerine will probably avoid a positive test. I don't know, I can't say that that's true. I don't know if that's true or not true. I don't know if apple cider vinegar is a good protection against this unfair system. But certainly some people say that it is, and there's no problem at all about that information being shared among the community. Some people will say, oh, I tried that, it worked, oh no, it didn't work for me. It's going to be a bit idiosyncratic, I think. But there's nothing wrong, and it's not interfering with the police in the exercise of their duty to say that to people, okay? Certainly there are offences about interfering with police I can't think of the exact words, but interfering with the police when they exercise their duty, that is an offence, it is charged. If you sort of interfered in a physical sense, walked over to the cop and stood in their way and don't that drivers, don't leave him alone, whatever, that would be the offence. But talking about things that may or may not provide a good screen to the screen is not a problem at all, legally speaking.
I wanted to ask, so if you do get pulled over, tongue swiped, and you test positive, when they sort of sit you down and give you the third degree, is it best just to say no comment and just get your ticket and then just go before the magistrate and then sort it out from there? Just make no comment. I've tested positive, that's it. You've got your facts, and then say nothing?
Yes. Short answer is yes, that's the best thing to do. The police will always ask you questions about it. That's their thing. It's a cop thing. They like to ask questions. They get trained to do that, and they will. The standard arrangement is slightly not standard. A two-part answer. If the case goes to court, it depends on, these days, first offenders just get a ticket, okay? So if it's not a first offence and it has to go to court anyway, the police will prepare what is called a fact sheet. That's a standard police document on cases that go to court, possession and other assaults, all kind of cases get a document called a fact sheet produced by the police. Depending on the case, that can be half a page long or 10 pages long. But it's just the police version of things, okay? For these kind of cases, there's a one-page pro forma, basically. They add in the date, they add in the rego number of the car, the time that they stopped you, etc., etc. Tested the driver, and a few things. But they normally have a provision that says, I asked the driver when she last used cannabis, and she said, oh, it was yesterday, or something, whatever, okay? So if you do say something, they write down what you say, okay? A lot of people will say, yeah, that's, what are you saying? Days ago, yeah, I had a smoke on Wednesday. Here, what's happening? So, people will say things like that, and the cops will write it down. People will say, look, I use medicinally, I've got a script. They'll probably write that down too, okay? So they write down one or two things that you say to them. It's often, in these cases, not a huge problem. It can be a more difficulty in other drug cases where you might be making admissions about an element of the offence that they can't otherwise prove, okay? In these driving cases, they just have to prove that you're the driver and that your saliva had THC in it. So whether you admit or don't admit using cannabis is neither here nor there. It doesn't matter as far as proving anything is concerned. So it doesn't sort of matter in that situation that you do say something to them, but you can just keep your peace, keep keep silent, keep yourself to yourself, and then when you go to court, if you do go to court, tell the magistrate what you want to say about it in terms of 2 or 3 days since you smoked, you were surprised to have the reading, use medicinally, whatever it might be that you want to say, as a way of an explanation about the circumstances for the court. I was saying earlier that what you say to the police has almost nothing to do with the penalty. It's what you do in court that affects the penalty. So making admissions on your first day in court gets you a long way in terms of reduction of penalty. Pleading guilty in court on day one is a big reduction in penalty. Making admission to the police doesn't do anything. You might as well keep your silence, get some advice, and you may not be talking yourself into a bigger trouble by staying silent at that stage. Okay? But yeah, hopefully this law will disappear in the next few years, but I don't think it's going to disappear. It's a very, very annoying law, and I think the best we can hope for is that we get the exemption for medical users pretty soon.
Steve, I think we might wind it up now. And yep, for the next speaker. So thank you very much for joining us for this, and thanks very much again for many years. Steve helps us every year with legal advice. So thanks a lot, Steve Bolt.
You're very welcome.